This is Chairman Christopher Iliff. I'm calling to order the meeting of the Johnson County Planning Commission for Tuesday, February 28th, 2023. Megan, if you want to read the notice.
Okay. This is a statement about the hybrid meeting. This meeting is now being recorded. Please silence all electronic devices. This meeting is being held in the board hearing room with Planning Commission members attending in person. There is also an option for virtual attendance on Zoom webinar. If you are using Zoom, you may participate in the meeting using your computer, phone, or other electronic device. Zoom participants, chat will be disabled once the meeting begins. If you have trouble with Zoom, please call 913-715-1700. If you would like to speak during the public comment section of the meeting, please use the raise hand function in the Zoom app to notify planning staff of your desire to speak. To activate this function, click raise hand in the webinar controls at the bottom of the screen. By telephone, you may raise your hand by dialing *9. We will take comments from in-person attendees first, followed by Zoom participants. The Zoom moderator will call on individuals who have raised their hand. The chairman may modify these procedures as needed to conduct an orderly and efficient meeting. All speakers will be limited to 2 minutes unless the chair designates a different time period in order to accommodate all the speakers. When your name is called by the moderator, your microphone will be unmuted. Please state your name and address for the record, followed by your comments. If you share concerns, comments, or points made by others, please refrain from repeating those comments and instead note for the record that you agree with the previous individual's comments. There will be a 10 seconds remaining warning sound. Board members and presenters, please state your name every time you begin talking, and please speak into the microphone so that the comments can be transcribed for the record. This is a public meeting. We are presenting live and recording the meeting. Thank you.
Let's do a roll call, please.
Jim Neese.
Present.
Roger Mason.
Present.
Randy Downing.
Here.
Chris Iliff. George Lund. Terry Atwell. She's present on Zoom, but she's not unmuted. We'll work on getting
Yeah,
her.
there it goes. It finally, I'm here.
Yeah, there she is.
Dave Johns is absent. Mike Levin is absent. Kelly Rast is absent. Lindsay Grisay.
Present.
We have 1, 2, 3, 4, 5, 6, 7. We have 7 members present. We have a quorum.
We do have a quorum. Thank you very much, Megan. I appreciate that. Now is the time for public comment for anyone who wants to address the Planning Commission on any topic that is relevant to the Planning Commission's job. You will have 2 minutes in order to make any public comments that you want. Hearing nobody, we will move on to the next item on the, next.
Mr. Chairman,
Yes.
Jay Leipzig, I have one thing I did want to note is that we received an email from Joyce Whittier on the sequestration of corn that is, I believe is on everyone's dais as well, and that was emailed to you all as well. So just note that for the record.
Yep, thank you. And I did have an opportunity to review that, and as did every other member. So thank you very much. I appreciate that. Disclosure of conflict of interest in ex parte communications by members. Hearing none, we will move on to the next item, and that is the approval of the agenda. All those, does anyone want to make any additions or deletions to the agenda? I would at this time just point out at the before adjournment, I would like to have a brief moment to discuss issue with regard to enforcement of zoning and subdivision regulations in the unincorporated area. And we'll do that after item I and before item J. Any objections? If not, then approval of the minutes. Do I hear any objections additions or deletions to the approval of the minutes for the meeting of January 24, 2023? It's been moved that we approve them. And seconded. All those in favor?
Excuse me, who seconded? Thank you.
All those indicate who in agreement by saying aye.
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 Sign. The minutes will therefore be approved. The next item on the agenda, and I'm going to turn this over to Mr. Leipzig for the introduction of our county counselor with regard to board member training.
Thank you, Mr. Chairman. Jay Leipzig, Planning Department. With us this evening is Peg Trent, who's our Chief Legal Counsel with Johnson County, is here to provide an update on a recent ethics discussion with the Board of County Commissioners, and as well as to an opportunity to answer additional questions you might have from a training that we had back in September 27th last year. And if you might recall, it was kind of a long evening and we kind of had to rush through the last few items. So wanted to give Peg an additional opportunity to go before this board and answer questions you might have as well, but then to also update you on some recent discussions concerning the ethics and with the Board of County Commissioners. Peg.
Thank you and good evening. I'm happy to be back again to kind of follow up from, I think it was last October when I last met with everyone and providing just a general board training. Since that time, we've had a new chair installed with the Board of County Commission. And one of the projects that the new chair brought forward was a project that a subcommittee, which I think you were aware of when you were initially looking at your bylaws, were reviewing the code of ethic, as well as rules of order of the Board of County Commission. And there were several recommendations that were made by that committee. That subcommittee comprised of Commissioner Allenbrand, Commissioner Myers, and Commissioner Fast. And also the clerk of the Board of County Commissioners, she was also present, as well as myself. As a result of it, there were numerous recommendations with the rules of order, how they operate and conduct meetings, as well as how they conduct business among themselves with staff and the public. Those rules of order for the Board of County Commissioners were adopted on February 2nd of 2023. There were 3 COWs that were held prior, committee of the whole, where they actually discussed the revisions and made further revisions. And that document is now posted online, just so if you're interested in it, for the Board of County Commission. And just so you're aware, the Board of County Commission adheres to the Roberts Rules of Order, but in certain places they do deviate. And so those are noted within the rules of where they are deviating from Roberts Rules of Order. So along that line, then, after the rules of order were adopted by the Board of County Commissioners, there was a committee of a whole held on February 9th. The purpose of that was to review the recommendations by the subcommittee related to the Code of Ethics. And I'm just going to go through, I have before you, and I believe, emailed, and also you received, I think last week, a copy of the Code of Ethics that were adopted by the Board of County Commission on February 16th. And ironically, where we left off in the presentation in October was on the Code of Ethics. So the timing worked out well as we move along in that training. So just to give you a kind of high level overview of the new Code of Ethics as opposed to the other Code of Ethics, the original Code of Ethics were adopted in 1988. And that was 34 years ago. And these are the new Code of Ethics. Well, when the board was reviewing the ethics in the subcommittee, the recommendations, because they are elected officials, the Board of County Commissioners, and appointed board and commission members, as yourself on this board, are volunteers, they felt that there should be a different standard and a level applying to to them as opposed to employees and appointed officials like myself and the county manager, that we're held to a different standard than you. And the reason being is the elected officials are held to compliance with the state statute on local conflict. And if they are not in compliance, it is a misdemeanor offense. So in also what was happening, we were finding is a lot of the conflict of interest was very broad and very subjective to enforce. And so they wanted more of a meaning that it was more measurable in determining when there is a conflict of interest. So it made sense to mirror the state statute on local conflict of interest, which would apply to you as well as to the Board of County Commissioners. Essentially, the first part of the document, and I don't want to scroll through quickly, but it went through where we had talked about you as serving as a board member, what your fiduciary duties, if you recall, were when we went through that, their last training in October. And also within the Code of Ethics, none of this changed. The statement of policy, what, Johnson County and what they're striving, and someone brought to my attention, is to maintain that trust with the public that you are expecting that you're adhering to these certain standards. So the policy is outlined it's the same as what we've had in previous years. You'll notice the font's a little different. It's a little bit updated. Grammatically, there were all kinds of errors in the 1988 version. And so we tried to just clean it up. The subcommittee did not change any of those 12 ethical standards. They remained the same. And a lot of them is what we discussed in the October training about loyalty, upholding the law, the Constitution, C, treating every resident fairly and what they expect from a public official. And public official includes you as a board member, as well as the elected officials for the county commissioners. It's refrain from making any promise, never engage in business with the government, either directly or indirectly, that's inconsistent with your performance as a job. Again, all the things that we reviewed back in October. Never use information that you gain confidentially in your role on this board in a manner that you're profiting or you're revealing any of that confidential information. Always safeguard that public trust. Again, that theme of public trust and making sure that we are above reproach in deciding issues that involve the public. Again, showing integrity, another word, which is a Johnson County value, highest level of integrity in performing your duties and knowing, not to lead others or be misled in the performance of your job. Again, the appearance of improper influence of receiving, soliciting, and accepting gifts, and never allow your judgment to be compromised by any family, business interests, or any part of your government service. Again, all of these were the same standards of the 12 standards that were in the original Code of Ethics. So as we move to page 3, this is a very short document. It's 7 pages total. The original document was 11. A lot was cut out because it was dealing with employees, and it was very complicated that when there was an ethic complaint, how it went through this process. One of the things that the subcommittee came up with is coming up with a procedure or mechanism that was simple in reporting and enforcing, as well as reporting and making sure there is compliance with board members and BOCC members. It still has the opportunity that you can request an advisory opinion from my office. At the legal department, if my office indicates that it is not a conflict, that is something you can rely on. If it is a conflict, that's when, and you continue to process it and not follow that, then it goes immediately to the Board of County Commissioners as a board member. And at that time, the commission gets a copy of the opinion that I render, and they can get an outside attorney to render a separate opinion, a second opinion, or they can have the individual talk to them, and then they make a decision of what to do. Again, the sanctions are the same as they were in the original. They can do nothing. They can dismiss it at any point. If I find, after looking at a complaint or opinion, that there is no conflict, then that's the end of it. It stops at that level. Keep in mind that this is a separate process for the Board of County Commissioners than the state conflict of interest. So they have two areas that someone could possibly challenge a Board of County Commissioners. So they can go under our ethic policy or the state statute, but you are only held to the ethic policy, not the state statute. The state statute, again, carries a penalty, a misdemeanor penalty, if they do not disclose substantial interest. And so this is where we're getting into gifts and gratuities and how that comes about. But I'm going to skip down to what's the most important, I think, is the conflict of interest provision. Under the conflict of interest, this has been revised, as you recall in your previous bylaws. And I will tell you, most of what you adopted and worked your hard work that you put together with the bylaws, there was a lot of carryover of what you had in the Planning Commission bylaws into the Board of County Commissions, their rules of order. The only thing that changed and dramatically was the conflict of interest because of enforceability and how to be accountable to the public. So the first paragraph, it's on page 6, which starts with conflict of interest, B1. It indicates that a conflict of interest would include any circumstance under which a public official, and that would include you, has a substantial interest as defined under state statute. So that's 75-4301, the conflict statute, or, and this is the second part of this, has a pecuniary, which means a financial interest in a matter, and the public official derives some direct and tangible personal or professional benefit from a particular resolution of the matter. So they're looking not only if whether you have a substantial interest, and there could be exceptions if something goes out for a bid, but you're not going to get into that particular issue with this type of board with approving of a contract. But if there is a substantial interest and you've met the exceptions under the state statute, there is a procedure that would not be a conflict.
Chimney, are the standards, conflict of standards and a conflict of interest, are they equal? I mean, are they, sometimes I get mixed up between a conflict of interest and a standards because they both sound about
Right.
the same.
Right.
And I don't know what the state statute says.
Mhm.
And I have, since last year, I had a couple of questions of mine, and really, what is it? What is a conflict?
Mhm.
And what isn't a conflict? And I thought about this driving here this afternoon. For example, I'm on the board of Commemorative Air Force, and there's something that comes up here that would affect that. If I'm on the board of that entity, whatever it is, it could be a church, it could be a company, it could be an association, is that grounds for me to recuse myself?
Mhm. Yes, it could be, because you could have, the second part of this is you could have a substantial interest or a financial interest in the matter in your role as a board member in a particular matter that's coming before you in your role as a planning commissioner. So, yeah.
I mean, it's from your, by the way, it was a great class you gave. I thought that was a great class you gave. And I guess my question is, at what point in time are we the ones that decide, I know these people on this particular company or this particular organization, and I have an opinion, but I don't have a financial interest.
Right.
And it seems like to me, a lot of times we would have to recuse ourselves many, many times.
Mhm. You're right. And that would be what was the appearance of impropriety. It's subjective. That's what we call bias too. That could be perceived bias. Everybody has some form of bias. As a matter of fact, probably why you were placed on and appointed on this board is because you have an interest in the certain issues that are coming before you in background. So you may have an interest or a bias, but that doesn't mean you can't put aside what you know. It helps you to be more knowledgeable, to ask the questions of that project coming in front of you. But at the same time, you should be able to put that aside to be fair and impartial as it applies to that particular project. So what
You leave
this,
that- you-
this helps you now, in my opinion.
Do you leave that up to us to kind of, I mean, hopefully we're all honorable people here and we're trying what's best and you don't want to have to stand before a zoning board meeting or before this
Right.
meeting and say, I've done this, I've done that and the other. And I guess maybe I'm just looking for.
Mhm.
So one of the things, this is Commissioner Grisay, if you look at 4.09, in the one that it's amended, because I had the very same concerns of what is this appearance of impropriety? Where do you draw the line of getting some tangible, indirect,
Mhm.
consequential, something we're voting on could help somebody that may know somebody who's a friend of somebody, like where do you draw that line? And I think we amended the words specifically to try to give a little bit of clarity to that. So it needs to be direct and tangible. And it's an and, not an or. So it's direct and tangible, personal or professional benefit. And so a pecuniary interest or a direct and personal tangible benefit. And while the appearance, I think, is a factor, I don't think it's the governing factor. You still have to have direct and tangible, personal or professional benefit. And so to me, that at least draws a little bit of a clearer line. So let's say you're on that board and, if there's some sort of indirect benefit that organization may receive, I think that you are well within your means, that you're safe, right? But if you're actually doing something that will have a direct benefit to them, then that's where you may want to seek, Ms. Trent's opinion. At least that gave me comfort. I was uncomfortable with how it was worded before because of this very concern of what is indirect, how far do you draw it? Ms. Trent, I don't know if that's
Standing.
if that
You gave a
helps.
Great explanation. Thank you. And to take that one step further, the board also wanted a mechanism. So you can look and say, how do I know whether I have a conflict? So the board wanted to follow for themselves the SSI, which is called the substantial, if you could put that up, substantial interest statement. They decided not to apply that to you because they felt it's public record. They're elected officials, so they have to disclose those publicly. They didn't want to subject you as a volunteer to have open record requests that would divulge your personal information. So and this is the form, just so you know, and I've now put together a chart to kind of help people to pull all the laws into and how to fill this out. So I'm working with the county commissioners to ensure compliance. So, but this form gets into a lot of personal information, and the commissioners directed and voted to take that out because they didn't want it. In the original draft, we had you filling out this too, and they decided not to. So now what we're doing, if you could put up the application form, now you will have the application form that you filled out to be a board member. You are now going to fill that out every year to give me a copy in my office that I keep. It's still public record, but I have ways also of looking to see if you have conflicts. And if you do, then I will reach out to you and have a discussion. So we have two attorneys that are assigned to planning and zoning now. It's Ryan Haga and Bob Ford, and I believe they both are online tonight. So they will be your attorneys that you would reach out to if you had any question on an item that's on the agenda that you may be reviewing or discussing in advance. In addition, the attorneys will also be looking prior to your meeting to be proactive. So we're not waiting till the middle of an item or somebody from the public brings it up. So here's the form.
Sorry, Miss Trent, I just had a quick, yeah, why don't you go
Yeah.
through the form and then I'll ask a.
Yeah,
question.
so the form, as you recall, you filled this out when you wanted to be a board member a long time ago, some of you. And what will happen is this form will be maintained by my office. It will get into the one areas that we will highlight with an asterisk that we want you is your right here, your current and boards and commissions, because some of you are on other boards other than planning and zoning and other organizations, nonprofits and community organizations. So you'll update that, update your information, of other items and just give us a good overview of everything about you. At that point, we will just continue to keep it on file. We'll be watching and looking for conflicts to help you. So we're taking a more proactive role as a legal department to help with the boards. And to have, that we're available, the attorneys to speak with you too.
Ms. Trent, this is Commissioner Grisay. One quick clarification. I just want to make sure I understand the way the rules are currently written on conflicts is to actually be required to kind of abstain and remove yourself. There has to be an actual direct conflict or you have to tangible pecuniary interest. Now, the legal department, I think, can raise or the public can raise, or you have a burden yourself to raise any things that you think fall into that category. If the legal group determines, hey, it looks like the appearance of a conflict, they don't know for sure, but there may be a bad look, perhaps. They can then investigate that, but you only have to recuse just the mere appearance of a conflict may cause you to have to temporarily abstain. But if once the investigation reveals there's not a direct and tangible interest, you could come back in. So I think that appearance question of conflicts is only intended for that temporary investigation.
We won't even be doing that. Ours is at this point, the standard. If you feel you have an appearance and you just don't want to even go down this road because it's too, controversial, you can abstain. You don't have to have a conflict. If something gives you pause of an appearance, you can say, I have a conflict and I'm not going to do it, or I'm going to abstain just out of the appearance of impropriety. So you have that burden, you have that choice. But us as a legal department and others, we're looking at this measurable standard. If you don't, I get asked this question now more frequently now that we've adopted this. And it's easier to enforce and to ask the questions and to know. As a matter of fact, I intend as we get more into this, I will probably have, I know in my previous job in Wyoming, I had a 3-part test and wrote an article on it. So I was thinking about doing the same for this so that you have a test that you can go through a litany of questions of asking. So I'm going to probably be putting that together as well. I just haven't had an opportunity as we were rolling this out. I'm going to have this form up on the legal department's website. So if you were looking for the form and you need to update, because we're going to have you update it before April 1, because it says so in your rules here, and you'll see where I have it in your bylaws now. You'll be able to go on there and I'm going to have it set up so you can fill it out and it shoots the email to me. So you don't have to worry about it. You've complied and that's all you need. You'll get an email back that we've received it and you're done with that.
Oh, Commissioner Grisay. So, and just on that first paragraph there, you have to have a pecuniary interest, and so both have to be true, right? And you have to derive some sort of direct and tangible personal or professional benefit from the thing that is the conflict. So it is a more clear, direct, I don't want to say heightened, but there is it can't just be a tangential thing. You have to have a pecuniary interest or financial and you get a direct personal benefit from it.
Okay, then if there is a complaint, we now are going to have that going through, and I will have a complaint form on my website that someone can do a complaint. As a matter of fact, we've already got, not on you, on another board, a complaint. And so what happens is that comes in. Now I have, I think, 14 days to investigate it and report back. Usually I resolve it. If we resolve it, you have a conflict and I tell you, you need to resolve it, they resolve it, we're done. If there is a problem and you're not resolving it, then it goes to the board makes a decision. So it's very simple now. We're not going to all of this, but we can get a second opinion. The commission has that opportunity to do what they need to do. So basically, in a nutshell, let me look here, that's pretty much it. All of this is confidential. If there is an ethical complaint, it's not to be released to the public. There is something that I wanted to have included because I think it's important that the public, and you see it with the state, that I'm making a report to the board to tell them how many ethical complaints I've had this quarter, and give a high level, like I had ethical complaint or an advisory opinion relating to use of logo. That's it. I don't get into who, what board, just so they know what type of complaints we're getting. It also gives us good for tracking and knowing what I need to do more training on and addressing to other people. So that's the code of ethics. So what we did, and there weren't many, can you pull up, I'm sorry for the bylaws. So you have the bylaws. Your bylaws, again, I modeled most of what I did. I was able to do the work and roll it over. I just cleaned up a lot of your language you'll see of making sure the board, it was very confusing what board, because you're a board. So we decided to do Board of County Commissioners. Also, we changed it throughout chair instead of chairman or chairperson to chair. So most of these are just stylistic changes and formatting issues. The meat, if you can see, I changed here Robert's Rules of Order as amended so that you know if it gets to, we're in the 12th edition right now. If it goes to the 13th, it'll be however it's amended. Scrolling down, I'm sorry, I'm scrolling fast, but again, all of these paragraphs you'll see, just capitalizing members, Board of County Commission, nothing of major revisions. Again, just stylistic. So we go all the way down till we get to conflict of interest. So this is where the revision occurred because we want you to be consistent with the Code of Ethics that was adopted by the Board of County Commissions on February 16th. So in this paragraph, it just captures exactly what was in the other, it has it backwards, if you will, because we had the other conflict versus statute, but it's the same and I didn't want to do it. But the one difference is if you abstain, you do not have to leave the room. You can stay here. You're counted as part of the quorum. That is permissible under Robert's Rules of Order. You cannot participate. You know, that's a personal. If you want to leave the room, you can. But what we're saying, if you leave the room, you're not part of the quorum. So let me tell you how that would play out. And we almost had that issue occur with you as the Planning Commission when we had all the conflicts and that occurred with the solar regulations. So there are, refresh me, 11 members. So to have a quorum, you have 7.
There's
How many members are there?
There's 12 spots on the planning commission. And we currently have 10.
Well,
We have
it's,
2 vacancies.
so your board is essentially, it doesn't matter whether there's a vacancy, you have to count it as 12. Okay. So then you would have, is it 9 as a majority, a quorum? You have to have 9. 7. Out of 12. Is it 11 or 12? Okay, 7. So you've got to have 7 members present to have a quorum. And with the 7, if you have 2 that abstain, okay, and you'll say you only have 7 present and 2 abstain, you do not have, and they leave the room, you don't have a quorum to vote on the issue. If they stay in the room, they're considered part of the quorum to go proceed the thing, but the 2 can't vote. So when you do, they're counted in the quorum. So you would need, in that case, if you have 7, you would need to have 4 out of the 3 to vote majority to pass an item forward. Does that make sense? And I don't have a chalkboard or visual to write this out, but is everyone tracking on that? Okay, I know you can. I just want to make sure because I know that that gets a frequent question I get with those numbers.
Yeah.
So 9 members shall be residents of the, let's make sure, this is 9. I'm just trying to make sure. I thought it was 11. Nobody does 12, odd even number, but the state statute says 12 in this case. Okay, so that was your main change on your bylaws of conflict. In addition, I just took out this extraneous information. The reasons for the disqualification for shall be not limited to the avoidance of appearance of impropriety. A member may inquire of the chief counsel for a determination. I just took all of that out because it's redundant. I just put in the language from the commissioner's rules of order and just dumped it over the same language. All appointed, and then I put in here that from the same language that's in the rules of, in the code of ethics, not rules of order, code of ethics. I dumped the language that you have to complete an application every year in April. And that if you don't complete it or you don't fill it out, then I'm to report it to the Board of County Commissioners. And basically that's your obligation and you have the burden. So let's say you somehow our office doesn't see a conflict or doesn't tell you. And you know you have a conflict, it's on you to report it. The burden isn't on the legal department or anyone else, it's on you to do it. Other than that, continuing on, as you can see.
Ms. Trent, so if for some reason the form isn't filled out properly, you'll first notify the member
Yes.
and then before it gets reported.
Yes, that's why I'm meeting right now with the commissioners to go through the form because I want to make sure everybody's in compliance. That's I want people to comply and you want to. Usually it's just because you're busy and you misread most people the form and what's going on. So my job is to get you or my staff to get you into compliance. That's our goal, overarching. If you don't do it or you don't follow through, then we go to the commissioners. But we don't want to be like the tattletale. We're trying to get you in compliance. So thank you for bringing that up. So moving on up to page.
Ms. Trent, really quick, could you stop at 6.06? Sorry, it's a
Well,
little.
let me get to
Oh, sure.
6.01. So we added, because we're trying to get everybody consistent with your bylaws. So everybody of your zoning will be the same. And we're also doing that with all the boards. We're trying to get them all consistent with bylaws. So the meetings of the JCPC, we also added and shall be adjusted as needed to be consistent with the holiday calendar of the Board of County Commissioners. So if the commissioners pass their holiday calendar, you will, and yours falls on a holiday or what it is, you're adhering to the Board of County Commissioner. Then you wanted 6.06. Oh, that's what I wanted to talk to you about. Public comments. You at this point do not have to have public comments prior to your meeting. At this point, that's up to you. I am giving you that option. I think I met with another zoning board and I said, yeah, you need to have it. That's not correct. You can make that decision. And the more I've thought this through with planning and zoning boards, you want people to come in because you're an advisory board on the items that are before you that you're considering. So if you're doing regulations on solar hypothetical, of course, you're going to take public comments because you have to statutorily public hearing, which we have in here, and that which I revised to be consistent with the commissioners to hold a public hearing. So you're going to take public comments. But what we don't want is you getting into hearing items that may not have any bearing on your authority as a board. However, when I say that, you also have the authority as a legislature, meaning you're passing regulations. So someone may come in for looking at the regulations of an area that they may want you to revise in the future. But we have to be careful that you're not hearing matters that could be under code enforcement or some other matter that's outside of your jurisdiction because that some of you are on zoning boards where this could carry over to another zoning board or a board of, what is it, review, or it could move on. So we have to be careful what's coming in front of the board. So I'm going to leave that to you. I'm not going to impose it. I'm just saying I see the value. And I know someone asked me of another zoning board and I thought about it and I looked into this. So this is up to you. I'm not going to, I just see problems with it. I think it's, you know what I mean? So I was going to pause there and get your thoughts.
Jim Neese, what about the county commissioners?
They have public comments.
They do.
Yeah, Commissioner Grisey, I just would say that I've always found the public comments, you know, while some may be slightly off topic, I've always found them valuable to and worthy of having.
Yeah, it has been my opinion for many years that in some ways we are kind of like the old New England meeting hall where people can come and they can say what they want, and we limit it to 2 minutes. And if they want to express opinions, pro, con, or otherwise about pretty much any topic, I think we ought to hear it. It's never been an issue in terms of delaying our business or keeping us from getting the matters resolved. I would, as a chairman, reserve the right to terminate somebody who decides to come in and talk about UFOs. But I might enjoy hearing their opinion, so maybe I wouldn't. So we'll at any rate, I think we're going to continue to have public comments, and I would encourage whoever my successor is to do the same.
So I'm going to go ahead, if that's okay, kind of the consensus. I'm not asking for a vote. Is there everyone pretty okay with leaving it in?
I have one, Jim Neese, I have one quick question. I don't want to belabor the point. But the chairman's laughing. Hey, according to the rules, I got 2 minutes. When I read that code thing, it says some direct and tangible personal or professional benefits. So tangible doesn't have to be part of it. The way I read that, or am I reading it wrong? It could be something direct and professional benefit. When you say tangible,
So-
personal or professional, and that's all, just a point I want to make.
So Commissioner Grisey, so look at the first part of the sentence. It says pecuniary. So it has to be pecuniary and tangible or professional. So you still have to have that pecuniary part, you know, the that is the word that gave me comfort, right? Is that pecuniary and direct. So it's like that has to be there, and then it can be or professional benefit. So it's like you have to have both. But maybe what are you seeing that's giving you concern? Is that?
Okay,
Okay, so I'm going to go ahead and put that back in. So we don't have to worry about that tonight. So I'll have Megan, she'll go through and finish that. So moving down, public hearing, we wanted to make sure we actually captured the process you were using. We used another paragraph. I don't know where we got that from. It was very simple. So we're just capturing what's in the county Board of County Commission and making sure that we're mirroring that language, and that's what you're doing. This captures exactly what you're doing in 611. 612 is public participation. I'm going to put this back because we're going to have public comments. So that specific time, that all comes back in. Okay. Because you're allowing public comments. The only other thing that I am changing that the board changed with the code of ethics, no longer does the speaker have to tell their address for many reasons, as you can imagine. Someone coming up and divulging their address, safety issues. So they do have to divulge what city, state, county, I think it's city or county of residence, so that city and state where reside is all they have to say. And if, so that way, if they're in Johnson County or what city, you'll know, or in the unincorporated area. This is all language borrowed from the county commissioners. It's actually, I think yours, I just reprinted, so it looks like it's red, but I think it's from your original, if I recall, because you were the original drafters of this. Ex parte, you already had, so there was no changes there. Again, just changing just members and things. So pretty much this is it. This is your revisions were just basically the conflict of interest clause. So at this point, it's up to you. Oh, and attachment to this is that application for the board. So that's exhibit 1 is the board application. Yes.
Roger Mason, under the ex parte, is a discussion with someone about an item that's coming up qualify as an attempt to influence?
If they do speak with you, since you're a legislative board and you're not acting in a quasi judicial manner, you would just simply divulge it here. So what you would say is if it comes up the matter, let's say it's solar, you say, hey, I happen to talk to one of these wind companies. They spoke to me about this. They provided me this information and making sure everybody has it. I'm not getting into, you need to, and it's something that's big. We may have your emails captured or putting them all up, public comments. It's just more comfortable if you're not talking to them so that you feel fair and impartial, but you're legislative. You're listening to the different advocates. Under the previous conflict of interest, it could get into appearance of impropriety. And that was another reason for it to be removed, the way it was previously written. So that's why you're trying, you're in a different situation, but be careful. Some of you are appointed because of your zoning, your dual appointment. If you're going to be hearing an application, related to that, and then we get into the zoning, that's going to create potentially problems. So you just have to, I can't sit here and think of when you're in doubt, go see the attorneys, Ryan Haga or Bob Ford, and talk it through.
Roger Mason again. I'm thinking more of not necessarily related parties to it. In the example you said, like power companies, I'm thinking of the general other public who, I work in the development community all the time. So we talk about stuff with other realtors / developers, that kind of thing. They have no direct interest in what's going on some of these things like that, but we would discuss them as how does it generally impact our county?
I would just
That's what
say,
I'm
so
thinking.
your other colleagues know what you kind of factored into your decision-making process. I would just, and I see the commissioners do this frequently, and they don't get into names. I had a conversation with a developer. Just thought you ought to know, a developer, we're talking about this, and it was, you don't have to disclose it as a conflict. Just when you're going around, talking on the dais here, that you would just say, when you're getting ready to vote or you want to make a comment, I talked to a developer, and a developer, had reported to me that this is going to be a problem with setbacks and the way that we have this. So that was, I just wanted all of you to know this was a developer. If that means something to you to tell who the developer is, then by all means. But what it's just doing is just making sure you're divulging and being upfront. And so everybody, transparency knows who you talk to, because we got rid of that appearance of impropriety now. But you don't, so we're hoping people will get into disclosing, if they have conversations about the item that's coming before you. Now, I'm going to take a pause because I know that my words could be twisted. I'm not saying bias, for instance. Hypothetically, let's say I am with a nonprofit organization, and this nonprofit tangentially has had business with this company that's coming forward. If I don't have a direct interest or anything, I don't have a conflict. I didn't talk to anybody. I don't have to disclose it, and they have nothing to do with what's before me. It's only when you talk to somebody and with ex parte about the item you're considering. You see what I'm saying? So that doesn't apply to that item. And I know that gets hard to understand between bias and conflict, but truly it's measurable item of conflict now. Okay, so that's it.
I've got one quick question.
Okay.
In your class that you gave us back in October, there was one thing that kind of blew me away. Is that you kind of said that, and I'm putting on my zoning board hat now.
Okay.
That if something comes up, we shouldn't, unless I remember this wrong, it was a long time ago, we shouldn't be going out, checking out an area. And I'm telling you, one reason I'm been on that thing for 42 years because I live in the area and I know it. And when something comes up, I go out there and look at where they're going to do this or going to do that to help form my opinion. And I don't think, I mean, you suggested that we shouldn't do that.
Yeah, it was a suggestion that you not do that, but if you do, okay, my suggestion under the ex parte communication as a zoning board member, you would disclose that I went out to the area. I didn't trespass.
Okay.
I went out.
Oh,
there.
that's right.
And you got to worry about that.
Yeah.
Trespassing. I went out to the area or I sat by the area. I looked at it. I observed this. You want the others to know what you considered, because that is potentially, that is a quasi judicial matter. So we need to know what you're doing. I encourage you not to do that, to let staff show you with their drawings and all of that. But I understand and get it because I'm a visual person as well, learning and looking at issues.
Well, a lot of times staff, Jim Neese, a lot of times staff look something on paper, but they don't know what's going on in the country. But
Yeah, This is Chris Iliff. I'll just have to say, I really back up Mr. Neese on this point. Going out into the rural areas and looking at potential applications and the effect that they might have. I always consider that part of my job as a zoning board member. And I certainly take into account your advice that we disclose that. But my personal opinion is that doesn't represent any kind of a conflict and I'm an inveterate trespasser too, so I'll just admit to that.
Yeah, it's not a conflict, but what it gets into is when you're in a quasi judicial matter, that's when the bias, if you can put aside and be fair and impartial. And sometimes if you go way too far, we may, and I know Rick Lynn had trained on this, he would have you do a disclosure that I know this and I know this, but I can be fair and impartial, in hearing this. And so that's what the case law and everyone says. And what we're trying to make sure is that you don't become biased, that you're listening to the public hearing and what's going on in this room. But I will tell you, I get it because I know going out in some of these projects, you've got to see the surrounding area, the trees, because the drawings don't always capture that visual. I get it.
This is Commissioner Grisay. I think what I hear Ms. Trent saying is there's no statute that prevents you from doing it, no regulation that prevents you from doing it. That the act of doing it may create other issues in the future, but you can help solve those by just disclosing it.
Jim Neese, I've got one other question. One of the things that you did in the class was that said, I'm going to say this wrong, but after a vote has been made by the group, that when we leave there, it's supposed to be kumbaya, okay?
No.
Pretty much. That's kind of the way you're supposed to, I don't remember your exact words, but
I know what you're thinking. It's
You know
one-
what I'm-
what the board
I don't
speaks
remember
is
the
one.
words you
The
said.
board speaks as one is probably what I said.
Well, okay, so my question to you is, we vote on something here tonight and I think I lose and I think everybody else was crazy for doing this.
Uh-huh.
Are you telling me I can't go home and tell my neighbor I'm on this board, I voted against it and everybody else I think is crazy?
No, you're entitled to your First Amendment right to speak your your individual opinion as to what you individually feel. But it goes back, and this is just what I'm saying, when you serve on a board, it's, you are, and I guess this is where you got the kumbaya thought, is that you unite in a board usually. And as a board member, you have to be able to, you're sometimes going to be in the minority, you're going to be sometimes in the majority. And I'm here to submit to you a minority opinion changes policy and makes others to see. So it somehow, when both sides are angry, and it comes in the middle, somewhere that is maybe good policy. And so that's not uncommon. You're going to be, not happy with the decision of the majority, but what you try to do is to speak as one, walk away as one, and realize that your opinion is heard. And then you move on to the next item to go. And so that's your prerogative to go out and be upset. Believe me, I've been upset about things in court decisions and cases I've tried. So, but I have an ethical obligation not to badmouth the judge. So you have to understand that's where what I'm trying to say is to be a good, functioning, healthy board, you're going to have differences. But it helps if that was the board's decision, wasn't my decision, but you move on. And, and quite frankly, when the board then comes to represent, the chair represents, and I think that's in here, the chair represents in your bylaws, the position of the board, and it's reported. And I know that we've had discussions about how it's reported. And that's a more staff issue and working with staff and how you want to see that reported. So yes, I hear what you're saying. You're welcome. And that's all I have for tonight.
Is this in a position where we can vote on it?
Yes.
If that's the case, I think I would entertain a motion to approve the proposed bylaws of the Johnson County Planning Commission with the revisions
got
that
it.
have been discussed with us tonight, and which I'm sure that Megan has made adequate accounting of. Yeah, so, but is there anyone who wants to make such a motion?
George Lynn, before we do that, what exactly now are we voting on?
We are voting on approving the bylaws that are before us of the Johnson County, Kansas Planning Commission
With corrections?
with the corrections
Okay.
that we have discussed.
Okay,
Motion? Is that a motion, George? Okay,
I would so move approval.
and a second?
Roger Mason, second.
All right. All those in favor of approving the bylaws as presented with the corrections discussed indicate by saying aye.
Aye.
Aye. All opposed, same sign. They are passed.
And then also, I think Megan provided you an acknowledgement of the amended Code of Ethics now from the Board of County Commissioners. We're also going to need you to sign off on that like you did on the original as well. And that goes to Megan then.
And when you say sign off on it, do we individually, each of us need to sign off on those?
Yes, it's I'm acknowledging you've received a copy of the revised Code of Ethics that were just adopted on February 16th.
What would be the most expeditious way for us to do that? I mean, I have a copy of the Code of Ethics here in front of me. I can sign it and date it.
We have the form, don't we?
Yeah, there's a form. You guys signed it previously for the previous version of the Code of Ethics.
Okay,
So staff will work with you on
A new form.
how to get that completed.
Ms. Trent, that does not require a notary, correct?
I don't
Notarized?
believe so, no.
Just signature.
Just a signature. So there's an acknowledgement form. I don't think did it get emailed out?
It was emailed out this afternoon.
okay. I haven't seen that.
Oh,
That's fine.
I could sign that sometime and get that back to Megan. I'd appreciate it.
I mean, I do have printed copies because I didn't know if you wanted me to hand out printed copies. Okay,
If you want to sign it right now, you're here, you can.
If you have a copy of it, that's fine. I don't have a copy.
We have
I don't have
access.
a copy.
Megan has
So
access.
you have copies?
Yes, we do have copies.
All right.
So I think that's all I have. I will periodically come back as new issues present itself so that I'm updating you on areas. And whenever you need anything, you have two attorneys also. But they will be the attorneys that will be providing legal services to you.
Well, I hope this board doesn't keep you too busy.
Oh, it doesn't.
Thank you, Ms. Trent.
Thank you.
Yep, thanks very much.
Thank you.
All right. The next item on the agenda is our updates and other business.
Chairman, members of the commission, Jay Leipzig, in your packet this evening is the summary report for actions taken to the Board of County Commissioners dated January 12th, 2023 through February 2nd, 2023. And with that, if there are any questions on that document, I'd be happy to answer those.
Hearing no comments. We'll move on to item I, the director's report.
Okay, thank you, Mr. Chairman. Jay Leipzig, the Planning Department. A couple of things for you this evening. I'll keep my comments very brief. As an update on the New Century Air Center and Executive Airport land use compatibility plans. We had January 30th, 2023, we had a developer stakeholder meeting. We invited developers, engineers, and architects. We're invited to learn more about the project, provide comments and concerns facing developers near the airports. The meeting was well attended and staff received great comments at that meeting. There was also a planning advisory committee meeting that was held immediately after that meeting. We had representatives from Olathe, Overland Park, Gardner, the Planning Commission, and the airport commission members attended that meeting as well. We also have a couple of public information workshops that we just recently held. We had one of our New Century was held on January 31st, was well attended. We also had a workshop for the Johnson County Executive Airport on February 7th. That meeting was not as well attended. However, we're working with the Public Information Office to market that event or market additional events in the future so we get more interest in that particular project. But planning staff is working with the county's information office to expand that outreach. There's also a project website been updated to include copies of the board's presentations at all the public information workshops, as well as there's drafts of chapters 1 and 2 for both the New Century Air Center and the Executive Airport plans are on the website. So I would encourage the public and you all to look at that if you do have questions, or if you review it for additional information at www.joco.org/departments/planning, and it's under the section land use plan updates. That's my comments on the airport updates. We are having a report out to the Planning Commission at the April 25th, 2023 Planning Commission meeting. Moving on to the Sunflower Army Ammunition Conceptual Land Use Plan. That update, the committee's been meeting. We had several meetings for the past couple of months to talk about that plan. We have scheduled a public information meeting scheduled for March 21st, 2023 at the Timber Ridge Adventure Center at 12300 South Homestead Lane in Olathe. So I said that is on March 21st. We'll have a subcommittee recommendation report out to the Planning Commission at their March 28th Planning Commission meeting, which is our meeting next month. And then a formal public hearing before the Planning Commission on the Sunflower Army Ammunition Plan or Sunflower Plan on April the 25th before the Planning Commission. And similarly to the other item, there's also a website that has all of the information concerning the land use plan on that. And so I would encourage the public and you all to look at that if you do have questions or if you would like additional information on that. The next item is future agenda items. We, as I recall, I think in December, I had mentioned as well as at our January meeting about having the City of Overland Park provide an update on their framework OP, which is their future land use plan or their comprehensive plan. Staff has agreed to attend the March 28th Planning Commission meeting and make a presentation that evening before this body. So the Overland Park staff will be here that evening and can provide an update on the framework OP plan. that evening. Also, we will be having a public hearing to consider adopting the draft zoning regulation amendments for the accessory buildings. You may recall, we've been talking about that the last couple of meetings. That public hearing is scheduled for March 28th as well. And that concludes my report, Mr. Chairman.
Fine, thank you. In accordance with my earlier comments with regard to adding an additional item to the agenda before we adjourn, I wanted to follow up on a matter that was presented to us last month with regard to a potential violation of our zoning and subdivision regulations. As you'll recall, those of you who are here and those of you who have read the minutes, Mr. Dugan came here to report on a concern that he had with regard to off-street lighting and how it affected his residential neighborhood. I, at the time, asked Mr. Penley, Sean Penley, what is the process when a violation is reported? And his response in our minutes is reflected the process. If a suspected violation is observed and staff determines that it is in fact a violation, a notice of violation is sent to the property owner and they will receive it by certified mail. They are then given a certain period of time to bring the issue into compliance, generally 30 days. And the concern that I had is that notwithstanding the new reporting process that we have online, which I think is really good. It's great. It's easy to use. It's easy to get to and that sort of thing. That Mr. Dugan had been making complaints to the planning department for the better part of a year. And the problem grew worse as the year grew to an end because all the leaves dropped off of the tree and the light about which he was concerned was directly flooding his neighborhood. So I just want to make sure that we are all on board and that the planning department is on board with making an expeditious resolution to these matters. If there's no violation, there's no problem. If there is a violation, then the landowner should be notified or the offending party should be notified and given an opportunity to correct it. And if they don't, then the necessary steps need to be taken to enforce it. Now, I will tell you, because I live in Stillwell, have always lived in Stillwell, I have taken the opportunity myself to go down and observe the light. It appeared to me to be a violation. We have a specific zoning and subdivision regulation in the county, which says with regard to glare that any lighting used to illuminate an off-street parking area, outside storage area or outside activity area, sign or other structure shall be arranged so as to deflect the light away from any adjoining residential zone and from the public streets. And this was directly going on to a residential area. And now there is a requirement that it cannot exceed 1 foot candle from the center line of the street if it's facing the street, or 0.4 foot candles if it is going into a residential neighborhood. That's the letter of the law. I didn't have a light meter with me, so I can't tell you, and I didn't go up to the edge of the property to check on it. Later, I was told that the light was redirected, and I saw it because I drove down 199th Street and was looking at a blinding glare of the light that appeared to be several foot candles. And it is now, as I understand, well, I observed it, it has now been directed 45 degrees back, so it's in between the residential neighborhood and the street. But in any case, it is not hooded, and it just appears to be a violation. Now, that's the letter of the law. We also have the Stillwell Community Plan, which gives not the letter of the law, but the spirit of the law in Stillwell, because Stillwell is a rural residential area. And we have some specific things about that I wanted to bring to the attention attention of our planning department and to this board. And that is, we're trying to make this a neighborhood that retains its rural nature. And with regard to that, we specifically ask that landowners undertake voluntarily efforts to encourage businesses and residents to limit their outdoor lighting to be sufficient for safety and promote the use of new lighting technologies to reduce glare. And I will tell you that that lighting technology has been available now for at least 30 years. Because if you look to the southwest of the offending light that I'm talking about, you see Evergy's parking lot where they have great lighting, but it is almost not visible off of the property. You have to come onto the property before it takes effect, and there it completely controls it. I don't know why that couldn't be done here, and there are good examples of where it has been done in Stillwell. And so I'm just bringing that to the board's attention because, as I understand it, since last month, nothing has transpired to really make any difference on this. So it's going to come back. And if it turns out that there's not an official violation and it's unenforceable, then, bad on us. But I do think that I want to take any citizen's complaint about lighting in Stillwell seriously.
Denise, we've had a couple people that have come to the zoning board and neighbors of mine that have asked me about this. And from what I understand, I talked to code compliant gentleman and he's part-time. And we have one person in the county that's an employee to follow up on these. And I mean, I go right along with you because it takes sometimes 2, 3, 4, 5 months to get an activity, especially when you only have one person part-time. So I think it's just, it's happened in our area a couple times. Can't fault anybody. It's just the way it is. And, here you got the chairman going out there checking out lighting. It's just, it's the way it is.
Anyway, I have nothing more to say on the topic.
I just, Mr. Chairman, Jay Leipzig Planning Department, I will say with that code enforcement, our portal, our complaint system that we have, it goes to, yes, you're correct, Commissioner Neese, that we have a part-time code officer, but actually that complaint goes to our planner of the day. So it's the code officer, could be the planner, because a lot of those many zoning enforcement cases goes to the planning department first, and then if it's referred out to for example, the building inspectors looked at that as well. So it's yes, you're correct. It's a part-time code officer, but we do have, there's several staff that look at that. So we try to respond as quickly as we can.
And this particular violation really only can be assessed after dark. So it would require somebody, staying late. What's that? Overtime. Yeah. Yeah. That's right. At any rate, any other items anybody want to bring before us here?
Chairman Iliff, I guess I was curious, is there, while this board isn't an enforcement board, we do have the mechanism to amend regulations to have required response times. And I'm just curious if, based on this experience, that might be something we want to look at to see if there needs to be a little bit more teeth or action written within the code.
I think this is a one-off.
Okay.
Yeah.
Commissioner say Jay Leipzig, I would also agree. Yeah, this case is a little bit unique in that, most code cases does take a while. It doesn't take 2 months, hopefully not nearly that long, but it does. There's a kind of a standard process you follow through in terms of notification and giving the property owner time to correct it. And then if that doesn't happen, then additional time and letters, and then it goes eventually to codes court. So it does take a while. However, I think our regulations are fairly consistent in terms of the approach and the language that we're using for enforcement. No, we're certainly going to look at that when we do our subdivision regulations update. Next year will be part of that, but that will be pertaining more to signage, for example, and those type of things. But the enforcement process is fairly consistent.
There a motion to adjourn? Moved,
Second.
seconded, all in favor?
Who motioned and who seconded?
Oh,
Randy Downing made the motion.
George Lund, second.
Thank you.
All in favor, indicate by saying aye.
Aye.
Opposed? We're adjourned.